If you own a gun in America, everything you thought you knew about your rights just changed. A federal appeals court dropped a bombshell ruling this December that's rewriting gun laws across the country. There are 10 massive changes in this decision, and some will shock you. These changes hand you new freedoms while creating legal traps you never saw coming. Hit subscribe right now because missing this could cost you everything. Here are the 10 changes every gun owner must know immediately. Law 1. Strict scrutiny as mandatory standard. Law 1. Strict scrutiny as mandatory standard. This first change is the foundation that makes everything else possible, and it completely flips how gun laws work in America. For decades, courts let the government pass gun restrictions without proving they were actually necessary. The November ruling confirms that every single gun law in this country must now pass what's called strict scrutiny, which is the toughest legal test that exists. Anytime the government wants to limit your gun rights, they have to prove three things. First, they need a truly compelling reason, not just a good idea. The government carries the full weight of proof. Now, this puts thousands of gun laws across the country in serious danger of being thrown out. But here's something even more critical that affects your wallet directly, and almost nobody is talking about it yet. Law 2. Law 2, Civil Liability Shield for Lawful Defense. Civil Liability Shield for Lawful Defense. If you ever have to use your gun to defend yourself, this next change could save you from financial ruin. For years, people who successfully defended their lives with firearms still got destroyed in civil court. A guy in Ohio shot a burglar breaking into his house at 2 a.m. No criminal charges were filed. The burglar's family sued him and won $400,000. A woman in California defended herself from an attacker in a parking lot. The attacker sued her for $1.2 million, claiming excessive force. The November ruling creates absolute immunity from civil lawsuits. When you use a firearm in lawful self-defense, the criminal who attacked you cannot sue for their injuries. The burden is entirely on anyone who tries to sue you. They have to prove your actions were criminal before a civil case can even start. But there's another change that determines whether police can even take your gun in the first place. Law 3, Law Enforcement Accountability. Standard Enforcement Accountability Standard. Police officers who violate your gun rights are now facing consequences they never had to worry about before. For decades, something called qualified immunity protected officers from personal responsibility even when they clearly broke the law. That shield just shattered for Second Amendment violations. Under this November ruling, officers can no longer hide behind qualified immunity when they violate clearly established gun rights. If they take your legally owned firearm without probable cause, they face personal liability. In Virginia last month, an officer confiscated a man's concealed carry handgun during a traffic stop. Even though the man had a valid permit and disclosed it properly, the officer just lost a $300,000 personal judgment. This creates real accountability that protects you from illegal police actions. Still, there's a specific type of place where the rules just changed dramatically. Law 4, Sensitive Place. Law 4, Sensitive Place restrictions narrowed. Restrictions narrowed. The government's favorite trick for banning guns everywhere just got shut down hard. States like New York, New Jersey, and California figured out a clever workaround. They couldn't ban guns entirely, so they declared almost every public location a sensitive place where guns were prohibited. Some states had lists with over 50 categories of banned locations. The November ruling destroys that strategy completely. The court established a strict two-part test for what actually counts as a sensitive place. A courthouse with metal detectors and armed guards qualifies. A school with security screening and police officers qualifies. But a public park with nothing but a sign saying no guns, not a sensitive place anymore. Private businesses can still ask you to leave if they discover you're carrying, but they cannot have you arrested just for being there. States are being forced to slash their sensitive place lists by 80% or more. However, getting permission to carry in the first place used to be its own nightmare. Law 5, Carry Permit. Law 5, Carry Permit Processing Timeline. Processing Timeline. The bureaucratic game of delaying your rights until you gave up just ended. For years, states with restrictive gun laws would receive your carry permit application and then just sit on it. 3 months would pass, 6 months, a year. New York had applications pending for 18 months on average. The longer they delayed, the more people would give up and stop pursuing their permits. Every state must now approve or deny your carry permit application within 60 days of submission. If the state fails to respond within that time frame, your permit is automatically approved by default. States cannot request additional documents after you submit your application, unless there's a specific legal deficiency they identify in writing. The 60 days starts when they receive your application, and it does not stop. If your application is denied, they must provide a detailed written explanation citing specific legal grounds. Several states are already reporting they've approved more carry permits in the last 3 weeks than they did in the previous 6 months combined. But carrying legally is only valuable if you know what you're actually allowed to have with you. Law 6, ammunition. Law 6, ammunition storage mandate struck down. Storage mandates struck down. The laws that made your gun useless in an emergency just got wiped off the books. Several states passed ammunition storage requirements that sounded reasonable, but were designed to make firearms ineffective for self-defense. Massachusetts required ammunition to be stored in a locked container, completely separate from your firearm. California mandated that ammo be kept in a different room from your gun. A county in Illinois required ammunition and firearms to be stored on different floors of your home. Think about what that means in a real emergency. You go to your safe and get your gun. Then you have to run to another room, unlock a separate container, load your weapon, and hope the intruder waits patiently while you do all this. The ruling states that ammunition storage mandates that prevent immediate access violate the Second Amendment by rendering firearms useless for self-defense. You have the right to store your firearms and ammunition together in whatever configuration makes sense for your personal security needs. The government cannot dictate how you store ammunition in your own home. Yet there's still the question of whether states were keeping records of what you bought in the first place. Law 7. Law 7, Firearm Registry Prohibition Enforcement. Firearm Registry Prohibition Enforcement. The gun registry that wasn't supposed to exist just got exposed and ordered destroyed. Federal law has prohibited a national gun registry since 1986. It's explicitly illegal for the government to maintain any system that tracks which firearms are owned by which people. But several states found a loophole. California's dealer record of sales system contained information on every handgun purchase going back to 1996. That's 20 million records linking specific people to specific guns. Hawaii required every single firearm in the state to be registered with local police, including the make, model, serial number, and owner's personal information. The November ruling calls this out directly and orders them dismantled. Any state-level database that tracks individual gun owners or specific firearms is illegal and violates federal law. These systems must be completely destroyed within 180 days. Every state that maintains these databases is required to send written confirmation to affected gun owners that their information has been permanently deleted. Several states are already challenging this, but the court made it clear that any non-compliance will result in contempt charges and daily fines until the registries are eliminated. Still, there's a particular type of license that was being used as a weapon against gun owners. Law 8, Federal Firearms License Reform. Federal Firearms License Reform. The ATF's favorite tactic for destroying gun businesses just became illegal. For years, the Bureau of Alcohol, Tobacco, Firearms, and Explosives used federal firearms license regulations as a weapon to shut down dealers they didn't like. They would show up for inspections looking for any tiny mistake in the mountains of paperwork that gun dealers are required to maintain. A transposed number in a serial number, a missing check mark on a form from 3 years ago. A gun store in Pennsylvania lost its license because the owner wrote 2022 instead of 2023 on a single form. A dealer in Texas had his FFL revoked because he used blue ink instead of black ink on transfer documents. The decision states clearly that the ATF can only revoke a federal firearms license if the holder commits an actual criminal violation, not administrative errors. The ATF must issue a written warning and give you reasonable time to correct honest mistakes before taking any action against you. This levels the playing field for small gun businesses and stops the government from using licensed regulations as a backdoor gun control method. But protection at home means nothing if you can't take your gun with you. Law 9, Concealed Carry. Law 9, Concealed Carry, Reciprocity Expansion. Reciprocity Expansion. Crossing state lines with your gun just became dramatically simpler. For decades, concealed carry permits were trapped in a confusing patchwork of state-by-state recognition. You could have a valid permit in Georgia, but the moment you drove into Florida, that permit meant nothing. Gun owners had to check complicated reciprocity maps before every trip and hope the information was current. People got arrested at traffic stops because they didn't realize their permit wasn't valid 20 meters across the border. The November ruling establishes a national baseline for permit recognition. If you hold a valid concealed carry permit from any state in the country, at least 42 states are now required to honor it. Your Texas permit works in New Mexico. Now, the ruling specifies that states cannot create additional requirements for out-of-state permit holders. If your permit is valid in your home state, it's valid in 42 other states. Period. You can drive across the country with your concealed firearm and stay legal.